Good afternoon, Your Honour. I am here today to represent April Morris with the intent to apply for her bail. Under Section 4 of the Bail Act 1977, a person accused of an offence and being held in custody in relation to that offence is entitled to be granted bail, unless the bail decision maker is required to refuse bail by this Act. Furthermore, the Victorian Charter of Human Rights and Responsibilities bestows Ms. Morris with the right to freedom of movement within the state, Section 12 of the Charter, and the right to liberty and security, Section 21 of the Charter. Your Honour, the charges of common assault, Section 23 of the Summary Offences Act 1966, causing injury intentionally or recklessly, Section 18 of the Crimes Act 1958, persons found drunk, Section 13 of the Summary Offences Act, and willful destruction and damage of property, Section 9 of the Summary Offences Act 1966, do not fall under a Schedule 1 or Schedule 2 offence where bail is not granted except for exceptional circumstances test. Therefore, Ms. Morris is entitled to bail, and the process of her application will follow Section 4E of the Bail Act, the unacceptable risks test. Firstly, Your Honour, the prosecution have claimed my client to be a flight risk and feel she will attempt to flee and not attend court, given she has a commercial pilot licence. We do not believe this is the case, given the current COVID restrictions placed on travel and Ms. Morris having no intention of leaving. However, we do acknowledge that there is still a possibility, and we are willing to surrender her commercial pilot licence as a condition of bail. Your Honour, the prosecution believe that Ms. Morris will obstruct with the course of justice, commit an offence whilst on bail, and interfere with the two witnesses that were seen, given she has long friendships with local gang members, with one being the president of the gang. She's considered as an influencer and is well known for posting messages and other information constantly online, and she also has a previous blemish on her record. However, this occurred 5 years prior. It was driving while suspended and no conviction was recorded. Therefore, these multiple offences would be her first official recorded offence. We do not believe Ms. Morris has any intention of obstructing with the course of justice. Although she does have a long friendship with these individuals in the local gang, with one being the president, we do not believe that this friendship holds a lot of merit, as there is not a lot of constant interaction or communication between these individuals. They are merely people who have known each other for a long time. And Ms. Morris's influencer status, although she's known for posting messages and information, it is not factual information or private information. It is more gossip or social media trends that she wishes to follow to increase her following. However, we do understand that these factors hold an enormous amount of risk, and therefore we wish to place an intervention order that stops any interaction or communication with the select individuals in the gang. And we also wish to remove all access of Ms. Morris's social media accounts to stop her posting anything on social media until this is all done. Your Honour, we also wish to put up a surety to further confirm the presence of Ms. Morris at her trial and to give more grounds for bail to be granted. Under Section 5AA(b) of the Bail Act, surety is a financial amount of money to give more strength to the bail conditions. Given Ms. Morris has been charged with multiple offences, injury and property damage included in those, and has a lot of high factors that could affect her bail, we are willing to put up Ms. Morris's shares of $75,000 and her savings of $50,000 as the surety. Therefore, a total of $125,000 will be placed on a bail condition as a surety. And if Ms. Morris fails to attend court, this $125,000 will be gone. Your Honour, we believe that Section 4E has been fulfilled and reasonable conditions have been placed to cover the prosecution's doubts over Ms. Morris and her not being able to be granted bail. We do not believe that Ms. Morris has any intention of obstructing with justice, not attending court, or altering or affecting the case in any way. She is the breadwinner of her relationship and the offences occurred given the homophobic slurs that Miss Morris was faced as she's in a same-sex relationship. When she was out partying and clubbing with her individual, the victim was throwing homophobic slurs and random comments which obviously upset Miss Morris. Given she was under the influence of alcohol, it escalated the incident quite rapidly. These conditions that we have placed of $125,000 surety, an intervention order to stop all communication with the select individuals that Miss Morris knows that are in the local gang, remove all access of her social media accounts, and to surrender her commercial pilot license, we believe fulfill the section of 4E, unacceptable risks test, and believe that she is entitled to be granted bail.